Hi there. My name is Kate Glover-Berger, and I'm a professor at Osgoode Hall Law School in Toronto. I'll start simply by saying thank you to Joel for inviting me to participate in your event. I'm delighted for the opportunity to provide an update on Canadian public law today. And actually, I think for the duration of the video, I'm going to pretend I'm there with you in person because I'm recording this from within a long lockdown here in Toronto. So I've been given the task of spending 5 minutes to provide an update on a major recent development in Canadian public law. And so what I'd like to do is spend 5 minutes and make 5 points about a trilogy of cases that were released about a year ago by the Supreme Court of Canada, in which the court rethought its approach to judicial review of administrative action. This trilogy is known by its lead case of Canada and Vavilov, and so I'll refer to it as Vavilov here. My first point is simply that Vavilov established a new approach to judicial review of administrative action. On the Vavilov approach, all administrative decisions will be reviewed on a deferential standard, the standard of reasonableness, and this presumption can be rebutted only in a very limited number of circumstances. That is, when a legislature has prescribed a different standard of review, and when the rule of law requires that a non-deferential standard, the standard of correctness, apply. And the court articulated, again, a very short list of instances in which the rule of law would require a non-deferential standard. The court in Vavilov also set out some very specific, some might say fairly intrusive, guidance on how to conduct reasonableness review, which is something that the Canadian courts have struggled with in the past as well. Second point is that this trilogy of cases is part of a pattern of rethinking judicial review in Canada. This issue has tended to come up about every 10 years when the Supreme Court tries to establish a new approach. And so even though the Supreme Court of Canada is a court that thinks about administrative law issues frequently and deeply, this issue of judicial review, how to do it, how to choose standard of review, and how to apply it, is kind of constantly unsettled in Canada, or always, at least always in motion. Third point is that the court justified its break from precedent in Vavilov on two grounds. First, trying to respond to long-standing and widespread critique from other courts, from council, and from the academy. And these critiques were kind of across the board critical on justified grounds, critical of the past approach to judicial review. And so the court in Vavilov was trying to respond to that. And the second reason, or second grounds that they used to justify this break from precedent, was an access to justice claim. The court said that they were trying to provide some simplicity to judicial review in order to offer certainty and predictability to applicants who had been harmed by government decision making and who were seeking a remedy through judicial review. Interestingly, these two justifications are also part of the pattern of rethinking. So these two reasons have been given in the past for why the court needs to rethink its approach to judicial review. And so it seems as though Canada is a jurisdiction that can't quite address those access to justice concerns and have a simple, predictable, certain approach to judicial review, despite trying. My fourth point is that this was a split decision. The minority judges were very critical of the majority's break from precedent, and in mounting their critique, one plank of their argument was a comparative analysis. So the minority judges said that apex courts in several jurisdictions outside of Canada have similarly stressed the need for caution and compelling justification before departing from precedent. And the minority judges looked to the US, the UK, Australia, South Africa, and New Zealand as comparators. With respect to New Zealand, the court said New Zealand's Supreme Court views caution, often considerable caution, as the touchstone of its approach to horizontal stare decisis, and has emphasized that it will not depart from precedent merely because if the matter were being decided afresh, the court might take a different view. Now, of course, you can tell me if the Canadian Supreme Court has accurately captured the New Zealand approach, but it was one of the ways in which the minority sought to persuade the majority not to have such a stark abandoning of existing precedent. Fifth and final point is that the majority in Vavilov really fails to tie itself and the case into the broader public law narratives in Canada. So Vavilov is a break not only from the standard of review and judicial review jurisprudence, but also from trends and lines of cases in constitutional law, including cases dealing with constitutional powers and the duty to consult Indigenous peoples whose rights are affected by government decision making. And so we'll be waiting to see really if the court in upcoming public law cases, if the court tries to tie Vavilov and reconcile Vavilov with those existing constitutional cases, or if Vavilov signals a real turn in public law jurisprudence in Canada more broadly. So thank you very much, and I hope you enjoy the rest of your event. Thank you for including me.